If you want to get to trial, do not have an artificially long witness list or a witness list that is accidentally too long. Do not confuse Department 1 that is going to get your witness list and see how long your trial is and have 8 witnesses there or 9 witnesses or 10 witnesses, and Department 1 looks at it, totals up your witness hourly time, meaning the hours of testimony, sees 20 hours and thinks you're going to be looking at a 7-day jury trial with the estimate for jury selection. What I mean to say by that is, for those of us who practice personal injury litigation or insurance defense litigation in Los Angeles County Superior Court, since about the mid 2010s, we've had the personal injury hubs. Recently, since October 15th, 2022, the hubs are beginning to be dismantled, and they're beginning to send out, cases have been sent out since that date to independent calendar courts, community courtrooms, if you will. Fair and good, that's fine. But the point is, if you're in the hub and you have a trial date and you have passed the final status conference, you have your exhibit book ready, you have your trial readiness binder, the judge has approved everything, you're now sitting there waiting for Department 1 in the Hill Street Courthouse, the Stanley Moss Courthouse, to determine if and where the trial coordinator can send you out to a department to try the case. In other words, you're in a Spring Street Courthouse, the Spring Street Courthouse, Department 29, 30, 31, 32, and they're waiting on the trial coordinator at Stanley Moss to determine, hey, when and where can we send this person out to trial based upon their trial estimate, your trial estimate. So don't put too many witnesses on. I've had this issue. I've passed the final status conference and the trial call, both sides. We put together the binders, we put together the exhibit book. We had an entire video on that on my podcast here on my YouTube channel. And one of the things that you have to realize is that's all fine and good, but the trial coordinator is going to look at the witness list you have and say, look, there are 16 judges in LA County that do only civil jury trials that are PI cases. Then there's another, some criminal judges that are also dedicated to do civil cases when there is time. What you are looking at, though, and what you're looking at when you're coming out of a Spring Street PI hub courtroom is that trial coordinator has to look at your witness list and say, yeah, you know what? We have a trial here that's being sent out from Department 29 Spring Street that's got 9 witnesses and it's got 20 hours. So that to us looks like a 7-day civil jury trial. We have to find a department out of the 16 that has that time, right? They can't, if you have a 3-day trial, they can stick you in and say, this guy's got a 3-day trial, he's got a 2-day trial, he's got a 5-day trial. They might be able to stick you in different, in a certain department. But if you don't have that, if what you're looking at is you're looking at you accidentally or artificially or made the mistake of listing too many witnesses. You have, 2 pain management doctors, the treater and the retained, and you don't really need them for evidentiary purposes. You need to ask yourself, why are you doing that? Your likelihood of being sent out is less because it looks like your trial is a 7-day trial instead of a 4-day trial. And it's going to be harder to be sent out. So when you have that issue, think to yourself, do I really need this witness? Am I really going to call the law enforcement officer in a rear end case where my client has been rear-ended? Why? Am I really going to call an orthopedic surgeon when I already have a pain management doctor? Am I really going to call a chiropractor when I already have a pain management doctor? If you have some evidentiary issue, People v. Sanchez, something like that, you need to think about that. But if there's no reason and you're just kind of scared or whatever, you need to think about it. Every witness you put on there, and when the tally comes in, that Department 1, they're going to think, you know what, this is a 7-day jury trial. We can't send them out today. So you're going to come back in 2 weeks or a month or 2 months, and you're going to sit there again for 3 hours until they figure out, can we fit in this 7-day jury trial? Can we fit in this 6-day jury trial? When in reality, it's artificial. You have a 3-day jury trial. Of course they could fit you in most likely, or it's easier that they can fit you in. I say this from personal experience. About 2 weeks ago, I went to to Department 20, I believe it was 32. It was 31 or 32. One of the Spring Street courthouses. We had a jury trial set that day for the third time. And it was our case. It was a car crash case, very simple case. The defense were denying damages. They were denying biomechanical stuff. But this is our third time that we were there. 2020 case. We were first on the roster in all the departments. 29, 30, 31, 32. We were first on the roster, and we didn't get sent out. And we're thinking, this is the third time. This is the third time we're here. What's going on? And the judge comes out. And she comes out and says, hey, listen, guys, you have a 7-day jury trial, right? And I said to myself, 7-day jury trial? What's going on? No. And she says, no, we totaled it out. We totaled it. Department 1 totaled the time. You have a 7-day jury trial. And we're thinking to ourselves, geez, what? And then I realized, wait a minute. My staff and the other attorney in my office put 2 pain management doctors and put an orthopedic surgeon that we're probably not going to call, and a law enforcement officer that we're probably not going to call. So now we have to come back 2 months from now in August and wait again for what might or might not be another trial call, hopefully a successful one. So what do? What does the judge recommend we do? And I do. Get back to the office, change the witness list, take off the witnesses that you don't need and you're not going to call. Okay? This advice is mostly for a personal injury case that some people, the defense likes to call a soft tissue case, an injection case, a pain management case, where you don't have a surgery, where you don't have a fusion-like surgery or some kind of scraping off the disc discectomy case, anything like that. If you have a bigger case where you think you might need a witness and you're going to list 15 witnesses, that's a different kind of case. But if you have a case where the highest level of treatment is X, don't list all the doctors. Don't do that. Don't list law enforcement officers you don't need. Don't list witnesses you don't need. Your chances of being sent out for a jury trial are less because you're putting yourself in a situation where Department 1 is going to be confused, or they're not going to be confused. They're going to look at it straight and say, this is a 7-day jury trial. We can't fit it. Tell them there's no departments ready. And the clerk's going to say, sorry, there's no departments ready. Your guys are going to have to pick a new date to come back. You don't want to be in that situation. Don't deny your client justice accidentally by not realizing that you have put too many witnesses on the witness list. And as a result, it's going to make it look like Department 1's got to fit in a 7-day jury trial, when in reality, it's a 3-day jury trial. Think about that next time. Just like they say, I sometimes violate this rule. Sometimes brevity is sometimes better than going on and on and on. Think about your brevity on your witness list in order to be sent out. Best of luck at your next jury trial.